Good afternoon, everyone. Welcome to our latest webinar on the zeitgeisty topic of fixed costs. Today, Anirudh and I are going to look a little bit at the fixed cost regime in general, but we are going to be sprinkling our talk with a little bit of cross-border flavouring, which hopefully will be of interest to those with a practice in this particular area. For some of you who do or have done holiday illness claims, fixed costs as a concept is going to be a familiar beast. For others of you who do overseas injury cases that are non-illness based, or who do other consumer or commercial contractual claims, debt claims, etc., with a private international law element, this will probably be something of a brave new world. And we hope in this talk to try and demystify it a little bit. We'll come on to the details of it in a moment as we go through the slides, but it is probably best to say upfront at the very beginning, fixed costs are no longer protocol dependent. In the olden days, if I can call them those, and indeed under some transitional provisions actually in the current days for some cases, foreign accidents didn't fall into any of the RTA, EL, PL protocols. Obviously, illness cases fell into the package travel protocol. But road traffic accidents, employers' liability, public liability cases that had that foreign nexus, in the old days, they were excluded from the various protocols, which meant that they were excluded from Part 45 because Part 45 was protocol based. Now, the new fixed costs are not predicated on the protocols, but they are predicated on the track, fast track or intermediate track. So broadly speaking, if it's on one of those two tracks, regardless of whether it started life in one of the protocols or not, it's going to be fixed costs. So we're going to talk about that and some exceptions to that as we go along. But it's probably best to say right at the very beginning, because this talk will hopefully be of interest to you and relevant to you, that it is now dependent on allocation and not those protocols. So the way it's going to work today, I'm going to kick us off by looking at the new rules in general, and then focusing in particular on the fast track. Anirudh is going to take us through the shiny new intermediate track, which now exists between fast track and multi-track. There's probably a good joke to be made there, portmanteauing the fast and multi getting faulty. Someone somewhere has probably already made that joke anyway. Tiny bit of housekeeping. If there are any questions as we go, there is a chat function. You can put them in the chat and we can address them at the end. Our emails are also, I was going to say they appear on the slide. They don't appear on the first slide, but they will appear on the last slide. So you can, of course, email us. Without trying to sing too hard for my supper, though, what I should say is that a lot of what we're talking about here today, allocation and then assignment to complexity bands and then fixed costs and exceptions and all these sorts of things, they're all going to be very, very much case dependent, fact dependent, and there really is no substitute in a borderline case for sending across some instructions to council to have a look at assignment, allocation, exceptions potentially to the fixed cost regime, etc. One question we're often asked, though, we will be sharing the slides. It's Thursday today. It will probably be Monday, I think, before we're able to get those slides shared. But preempting any questions about sharing of the slides, we'll be able to do that, of course. All right. So that's the sort of preamble. If we kick off now with our first slide. So how did this all happen and what is its basis? Well, it is the charmingly titled Civil Procedure Amendment Number 2, Rules 2023. And what those amendment rules, they do the general CPR amendment stuff in various bits and places. But the important stuff for the purposes of our talk is they really rewrite to a full extent Part 45. So we have a brand new Part 45, and they rewrite to a certain extent Part 26, which is the early case management part of the CPR. Now, these amendments to the CPR came into force on the 1st of October 2023, so we're 6 months, 7 months in now. But Rule 2 provides some transitional provisions. The amendments to the CPR, which concern allocation, complexity assignment, directions on the new tracks, and costs, so the stuff we're interested in today, they apply as a sort of general rule by default for all proceedings issued after the 1st of October 2023. So if your proceedings that you're interested in were issued before that date, then it's the old regime. If it's after the date, it's the new regime. A little bit of a grey area, of course, as there always is on what issue means. Is it when the court actually issues the claim form, or is it when the claim form is received? I don't think I've seen any litigation that's resolved this one way or the other. But typically in English law, it's following the normal limitation arguments. Normally one looks at the date of being sent to the court when the court actually receives it rather than when the court gets their act together and issues it. That's the default general position. For personal injury claims, except for disease claims, they apply where the cause of action accrues after the 1st of October 2023. So for all of those injuries which occurred in 21, 22, 23 that are still within limitation, that the injury occurred before the 1st of October and proceedings haven't yet been issued. If proceedings are issued now, transitional provisions will apply, and we're still under the old regime for those cases. For disease claims, and I'm not sure what the explanation for this is, but for disease claims, the relevant date is when the letter of claim is sent. So if you get your letter of claim in, or if you have got your letter of claim in before the 1st of October 2023, then you're in the old regime. If your letter of claim is late, then it's the 1st of October 2023. Okay, so what does that mean? Well, it means, unfortunately, all of us as practitioners now are working with our foot in two areas simultaneously. We've got to change well, I'm changing my metaphor now, but we've got to change our hat depending on what the case is that we're looking at. And it's going to be a little bit like that for a while. Practitioners in our space, in the cross-border space, are quite used to wearing two different hats for two different times because we had all of that, dare I say, mess that came out of the Brexit stuff and the transitional period and thereafter. And we have the kind of bifurcation of claims pre and post Brexit. We're going to have the same kind of bifurcation of claims in the cross-border space for those which are under the old regime, under these transitional provisions, and those which are now under the new shiny post-October regime. So important to remember which hat you're wearing at any given time. We can find the old Part 45. Annoyingly, it's been taken off gov.uk, which is not particularly helpful for anyone who's trying to access it quickly. It's been moved to 45X in the White Book. So if you need those rules, remember that's where you can find it now. And if you start looking in the new Part 45, you're going to get very confused. So 45X in the White Book for the old rules, not available on open source on gov.uk, unfortunately. All right, if we move on. So where do we begin? Well, it all is dependent, as I said at the beginning, these fixed costs now are dependent not on the protocols, but they are dependent on what happens in the first case management phases of the case, which are, of course, allocation and new assignment, complexity assignment, that is. So we have to look at the new Part 26 and what it tells us. So Rule 26.14, where a claim is allocated to the fast track or the intermediate track, the court must assign it to a complexity band. So it happens at the same time. We can't say, well, let's allocate it to one of these tracks and we'll think about complexity later on. No, we need to be thinking about complexity straight off the bat. And this is important because the allowable costs are going to be commensurate with the complexity of the claim. And so you want to know, as legal representatives, you want to know as soon as possible what those costs are going to be. One of the benefits of the fixed costs regime, as it is advertised, is that it provides certainty to the parties. And so if we get allocation and assignment done early doors, then we have that certainty. We know what those fixed costs are going to be at an early stage of the claim. And so, as legal representatives, we can allocate our resources within our firms, or as counsel, we can allocate our resources accordingly and not spend huge amounts of money on cases that we know are in complexity band one. And well, we'll never spend huge amounts of money for any of this because the numbers are low, but we might spend a bit more money if we know that we're in complexity band four, and we can afford not to run at a loss. So that's complexity. So Rule 26.7 gives the process for allocation and assignment. It's the same as under the old system, except we've now got new stuff to deal with in our directions questionnaires concerning assignment. But essentially, it is those directions questionnaires which form the basis. We have DQs, which we fill in, which say we want this to be allocated to fast track or intermediate track, and we think it is complexity band 1, 2, 3, 4, whatever it might be. As ever, you can support your DQs with some written submissions on directions, which include written submissions on allocation and assignment. And if in doubt, the court is going to convene a case management hearing, an allocation hearing, an assignment hearing to determine the issue. Obviously, the simplest thing is that both parties agree, and it can just be all done straightforwardly by agreement. But where there's doubt or a serious issue to be resolved by the court, we're going to have some case management hearings. Now, special provision under 26.77 as to multiple claimants. The court can order at the allocation or assignment stage whether or not where you've got multiple claimants, each of them is going to get their own fixed costs. That's, as I suppose, the default position, or whether the costs are calculated together under Rule 45.4. Now, I'll come back to Rule 45.4 in a few minutes' time, but it's essentially if you've got multiple claimants who share the same legal representative and whose cases are fundamentally the same, really. The same issues are in dispute and they stand or fall together, etc. The court may consider that it's in the interest of justice to apply 45.4. As I say, I'll look at that in a minute, but essentially what it does is it says instead of each claimant getting their own costs, default position, you'll get one set of fixed costs for, let's say, the lead claimant, and then every additional claimant will get 25% of the allowable costs on top of that. So significant cut, as it were, where there are multiple claimants. But I'll come back to that when we start talking about 45.4. But the reason for that is that we do this in Part 26 is for exactly the same reason as I've already said about costs being commensurate for complexity bands. We want to know as early as possible what costs we're going to get so we can allocate resources within our firms and as counsel to the cases where we know we're going to recover money. We are profit-making organizations, and as I say, if we know we're going to only be getting 25% extra per extra claimant in a case where we've got multiple claimants, we're going to assign our resources accordingly in order to try and make a profit. So that's 26.77. 26.18, reallocation or reassignment. Well, it's always been possible to reallocate. This clarifies it's also possible to reassign, but there needs to have been some kind of change in circumstances, and it needs to justify reassignment. It's going to be cases of the overriding objective, proportionality, etc. The usual arguments. Oh, this has suddenly got more complicated than we thought it was at the start. We need this to be either reallocated to a different track or reassigned to a different complexity band, etc. And that is open by 26.18, but it requires justification. All right, if we can move on, Anirudh. All right. So rules for fast track allocation, well, they're fundamentally the same as before. We're in CPR 26.9, and annoyingly, have to read 5, 6, and 13 altogether. Pardon me, that should be 26.6 and 26.13, not subparas 6 and 13. What are the key things? Well, key thing is value. Value falls between 10,000 and 25,000, same as ever. 1 day trial, one expert per party giving oral evidence, no more than 2 expert fields, and then the 26.13 general considerations: complexity, remedy, number of parties, counterclaims, additional claims, oral evidence, how much is going to be required, the importance to non-parties, public importance, etc. What the parties say in their DQs, what the parties' circumstances are, and of course, the general overriding one that everyone considers in every case: justice. The overriding objective: justice, doing justice between the parties. So, most important thing, as ever, is the value, the length of the trial, and this little bit about expert fields. But those general considerations are always in play. Everyone will already be very familiar with cases that are worth, below the small claims limit, justifying fast track because of complexity of issues. Other people will be well aware of cases that are worth 50, 60, 70K coming into the fast track because actually the issues in dispute are really narrow and it's not going to last more than 1 day, and there might not even be any oral evidence from any experts at all. So fast track, really, allocation is the same old, plus ça change. Next slide. So the new stuff is assignment. Now, assignment is complexity, and there are 4 bands, and they are set out in Table 1 in CPR 2615. I've listed them all on the slide here. Band 1 is for your road traffic accidents which don't include a personal injury claim and defended debt claims. Band 2 is for your road traffic accident protocol personal injury cases. So for those of us working with a cross-border side to our practice, that won't include your foreign RTAs because they are non-protocol claims, and they are accepted from the protocol, so they won't be band 2. Package travel protocol personal injury claims also in band 2. Those are your gastric illness cases. Very familiar to many cross-border practitioners. That was the new protocol that was introduced a few years ago to cover only gastric illness. So it doesn't cover slips, trips, etc., other PTR claims, other PTR PI claims, I should say. Band 3, that's your RTA non-protocol personal injury. So that's the stuff which cross-border practitioners will be more familiar with. Employers' liability or public liability personal injury cases, possession claims, housing disrepair, other money claims. I should say ELPL claims excluding disease claims for band 3, because band 4, we've got disease claims, EL disease claims, with the exception of noise-induced hearing loss, which is dealt with separately. More complex possession or housing cases, property or building disputes, professional negligence claims, and everything else which goes into the fast track, but which is nonetheless complex. So that's a general catch-all provision within Band 4 to pick up anything else which has been decided is good enough for the fast track, but is not otherwise covered and is otherwise complicated. We'll move on. Okay, so with our cross-border focus, our seasoning in this talk, foreign road traffic accidents with personal injury, as I've just said, they don't fall under the protocol, so they're going into Band 3. Package travel regulations, gastric illness cases, as I've said again, they do fall under the PTR protocol, they go into Band 2. Package travel, non-gastric injury. Now, although these are technically contractual injury claims because you are bringing a claim under contract for breach of an implied term under the regulations that you're going to provide your accommodation services with reasonable care and skill, etc. And you don't typically have, no matter how hard people try, a parallel common law public liability claim in negligence. So typically, these aren't technically public liability cases because they're contractual liability cases. Because of their close similarity with public liability cases, I would argue, Anirudh might have a different view, but I would argue that these will highly likely be looked at as having the same complexity as a PL claim. They are materially identical. It's just that they happen to be pleaded under contract rather than under common law negligence. They're very likely, I would suggest, to go into Band 3. Package travel regulations, non-injury cases. So these are your consumer compensation refunds, all manner of other arguments that you might have under the PTR that don't involve injuries. These would be other money claims. These would go into Band 3. Next bullet point, non-package travel regulation injury with a foreign law element. And non-RTAs as well. So accidents abroad that don't have the benefit, if I can call them that, of having arisen under a tour operator package travel contract. These would be Band 3, and that's because ELPL claims are not restricted to ELPL protocol claims in Table 1. So even though these wouldn't fall under the ELPL protocols because of the foreign law nexus, in 2615 Table 1, protocol's not specified, so starting point would probably be Band 3. But as I say in the final bullet point on this slide, there's likely a good argument, potentially a very good argument, depending on the particular case, that if it is a non-PTR injury with a foreign law element and there are issues of foreign law, maybe there's a Spanish penalty interest issue, maybe there's other issues of what's going on in foreign law, either as to breach of duty, causation, or quantum, it's likely going to be a good argument that, notwithstanding its natural beginnings in Band 3, this case should be upgraded to a Band 4 FT case where the criterion is met, where it's a complex case and goes into Band 4. So Band 3 or 4, really, for those types of cases, I would suggest. All right. So that's allocation. Part 45 fixed costs is now entirely dependent on allocation. So gone are the days of the protocol dependency. To make that abundantly clear for the fast track, and it's also repeated for the intermediate track, CPR 45.43 says this section applies to any claim which would normally be or is allocated to the fast track. Any claim, not just a X protocol claim. So any claim allocated or ought to be allocated to the fast track is covered by Section 6 of the new Part 45. So it covers the full range of cross-border work if the case is allocated under Part 26 to the fast track. And where do we find them? Well, in the old days, we got the tables within Part 45 itself. They've now moved the tables into the practice direction. So the fixed recoverable costs for Section 6, which is fast track allocated cases, is now found in Table 11 in Practice Direction 45. And the disbursements are in Section 9 of Part 45. So we have to look in sort of different areas at once. In some ways, it makes more sense for them to be in the practice direction rather than in the face of the rules. In other ways, it's a little bit annoying that we have to flick between the rules and the practice direction to get the numbers. But there we are. That's where we are now. So Table 12 of Practice Direction 45. I think I said Table 11 in the previous slide. I'll correct that before we send that out. Table 12. So there are 4 sections to the table. Sorry, that's 3. There are 4 sections to the table, A to D. A to C are the how the costs vary depending on the stage at which the claim completes. Section D is the trial advocacy fees. Now that says facile again. I'll try to change that before we send the slides out. Okay, so Section A gives us subdivisions for cases which are settled prior to the claimant issuing proceedings under Part 7. Section B for issued but settled before trial, and then splits it by, in the same way as the old regime worked, after issue but before allocation, after allocation but before listing, after listing but before trial. Now that's I've never really understood the allocation and listing divide, because depending on the court, some county courts do this two at the same time. So the moment the case is allocated, it's also listed for trial on standard fast track directions in some county courts, because the whole point of the fast track is when we allocate it, we also direct it to trial and we try and get there as soon as possible. So very often in the fast track, you have your listing date comes at exactly the same time as your allocation. Not always. It varies by court, but sometimes it does. And it seems to me a little unreasonable that you automatically then get a bonus few thousand extra just because a county court deals with it in a particular way differently to another county court. But there we go. And Section C is the full costs all the way to and including trial. The next slide sort of explain that in a little bit more detail. I'm conscious of the time, so I'll just rattle through them. Section A, it starts at 0, and the reason for that is really because for Band 1 complexity, if you remember, those are debt claims and RTA non-injury claims. Well, in those cases where damages are not more than 5,000 or damages are not more than 10,000, I should say, they should normally be allocated to the small claims track. And so you shouldn't get any of the costs for complexity band 1 for pre-issue in these cases, because they would probably go into the small claims track, and you only get on the small claims track recoverable costs, I think, of 100 quid or so upon issue. So there's a reason why it's 0, and it is consistent. It's not an error. And then I'm not going to read out the numbers. You can all read for yourselves, but it tells us what the particular numbers are. I think these might be actually slightly out of date, these numbers, because of the because of inflation since the date. So I will make sure those are addressed in the slides before I send them out. Anirudh, if we can rattle through. Again, I'm not gonna read these out. We've already covered these, and again, these numbers are slightly different because of inflation. So I will change them before we send out the slides. If we can nip on to the next slide, Anirudh. And again, this is section C, trial costs, and again, same point about inflation since these slides were drawn up. So skip this one, and trial advocacy fees, again, not going to read it out. So just a couple of points. Specialist legal advice, Rule 4546, where it's normally assigned to complexity band 4, so we're talking about band 4 cases here. In addition to the costs allowable in Table 12, the fixed costs may include, so it's still discretionary, an amount in accordance with Table 13. And Table 13 tells us that we can recover for post-issue advice in writing or conference of £1,000, drafting of a statement of case of £500. These go on top of the Table 12 costs, and they must be justified. The presumption is for only one advice, either writing or in conference, but the court can award a further sum if the additional advice is justified. Disbursements. Now, this is a little bit clumsily written, and indeed, you can see it's clumsily written, not least by the fact that 4559 doesn't have a 1. It just goes straight into A, which suggests there was tweaking up until publication and they didn't get it sorted in time. But the allowable disbursements on a fast track allocated case under 4559A, that points at disbursements for protocol cases. Medical records, medical reports, non-medical expert reports, telephone hearing provider costs, engineers' reports, database searches, etc., etc. It doesn't actually say what would happen in non-protocol cases, which many cross-border cases would be. The assumption would be if they are reasonable and justified for protocol cases, then for non-protocol cases, of course, these are going to be reasonable. And if we look at 4559B, what we're allowed in any other type of case, non-protocol cases, any disbursement which has been reasonably incurred, other than a disbursement covering work for which costs are already allowed in Section 6, i.e. mostly council disbursements. The reasonable incurred will cover everything that's under 4559A, which points to the protocol costs, even for cases which are non-protocol. Multiple claimants, I said I'd mention these briefly. So the general rule, each claimant's entitled to the cost of their own claim in accordance with the applicable rules. That's CPR 45.5 sub 1, except joint entitlement to a joint remedy under CPR 19.3. So that's where you add a claimant, or you have to add a claimant where they're jointly entitled to the same remedy. Or you've got separate claims who've got the same legal representative, and the court has ordered that 45.54 applies. For the guidance on when the court will order whether 45.54 applies, we go back to Part 26, because as I keep on saying, the important thing here is certainty, and we want to know from as early on as possible whether we're going to get one of these multiple claimant orders or not. CPR 26.77B tells us the tests. So when considering whether it is in the interests of justice, so again, as ever, overriding objective justice, to make such an order, it shall have regard to whether the claim of each claimant arises from the same or substantially the same facts and gives rise to the same or substantially the same issues. The obvious implicit meaning of that being, if it does arise from the same or substantially the same facts, and it does give rise to the same or substantially the same issues, the court is going to be making an order under 45.54. And in those cases, the additional claimant is entitled to only 25% of the principal claimant's fixed recoverable costs, as I've already said. Important thing to say is that this happens at the allocation and assignment phase. We need to make sure that we get one of those orders at the time, so we get that certainty about what's going on at allocation and assignment phase. Next slide. Okay, London weighting. So where the receiving party lives, works, or carries on business in any area set out in Section 2 of Practice Direction 45, London, and instructs a legal representative with conduct of litigation who practices in any of those areas. The fixed costs shall include, in addition to the costs allowable in the relevant section, an amount equal to 12.5% of those fixed costs. London weighting. So both the receiving party and the legal representative has to be in London or practicing in London in the case of the legal representative to get that London weighting. So for foreign accident type cases, it's probably not going to cover a circumstance where your claimant resides in a foreign jurisdiction and is instructing a London-based firm. Yes, fixed cost excludes disbursements. Vulnerability, this is dealt with in two ways. One, under Part 26, if the claim is one involving abuse or neglect or harm by or to a vulnerable adult, then you're going to be allocated to the multi-track anyway. So you're not going to be here. We're not even going to find ourselves in 4510. But if we do find ourselves in 4510 because it is not a case of abuse, harm, or neglect by or to a vulnerable adult, then if the party or witness is vulnerable, that vulnerability has required additional work to be done. So it's not just the fact that they're vulnerable, but actually, because they're vulnerable, everything's got more expensive. And by reason of that additional work alone, the claim is for an amount that is at least 20% greater than the amount of fixed recoverable costs. So that extra work is effectively 20% or higher of the full value of the fixed recoverable costs in the claim. Then you go to consider an amount of cost greater than the fixed recoverable costs, and you can go to assessment on the standard basis in those circumstances. And of course, we always have, when thinking about vulnerable parties or witnesses, we always have Practice Direction 1. All right, that's me talking over. I'm sorry, I've probably eaten into some of Anirudh's time, so I apologise to everyone and indeed to Anirudh for that.
That's perfectly all right, Tom. Well, good afternoon. I'll be dealing with claims on the intermediate track. That title page has a very threatening aura, but in reality, it's fairly simple and intuitive once you drill down into the basics. The intermediate track really sits between claims with a value of £25,000 and £100,000. Now, to really grapple with how this works, the best way is to think of an example. So, let's imagine you've got a client comes in with this case. Astrid goes on a package holiday to Cape Verde. She dies in a water skiing accident, and her estate and dependents bring a claim against the package tour operator. Claim value, you think, having had your first conference with the dependents and estate, valued around £70,000. If you're the defendant, you receive this letter of response, you make inquiries, and you deny it on three grounds. First, that the water skiing activity was not part of the package contract, there was no breach of local standards, causation is not admitted or indeed denied in relation to that. So that's our case. So what do you do when analysing the crazy world of fixed costs? First thing, does it fall within any of the exceptions? Now, CPR 26.9 subsection 10 gives a number of exceptions, but what's relevant really for travel practitioners are these two. Uh, First is where clinical negligence claims. That should say just purely clinical negligence claims. It's only when breach and causation are admitted, then it falls into the immediate intermediate track. But in general, clinical negligence claims fall into the multi-track, and claims involving harm, abuse, or neglect of or by children or vulnerable adults. And the upshot of this is, if I were a claimant practitioner in cross-border work, these two areas, clinical negligence and cross-border abuse, are likely to see an upsurge because you essentially avoid the issues of fixed costs, which I'll come on to now. I should also note CPR 45.1 subsection 6 provides that fixed costs do not apply to protected parties. Uh, this is likely to apply to claims in which the claimant lacks capacity rather than to children claims. And costs of incurred or in connection with inquest proceedings are not caught by fixed costs. Prior to April 2024, APIL had issued a judicial review on one of these issues, and the government later confirmed, and they introduced a new version of the CPR, indicating that it would not touch inquest proceedings. So Astrid's case clearly falls within the intermediate track of fixed costs. And that's because we've looked at CPR 26.9 and 26.13. It's a claim unsuitable for the small and fast track. It's limited up to £100,000. I appreciate looking at the facts of the case. It's unlikely to go over 3 days. Oral expert evidence, probably limited to maybe just one, if maybe two experts, and can be justly and proportionately managed. It's sort of case which the drafters would be caught into this regime. So we've established that it's in the intermediate track. Now, what do we do about the complexity banding? Now, having looked at the going back, there are three issues: water skiing activity not part of the package contract, breach of local standards of there's being a denial, and causation there being non-admission or denial. So looking at this overall, I'm not going to go through each and every single one of them because most of you can read. But if you can look through here, my view is that it probably would fall under complexity band 3. It's a quite complex claim. It's not given essentially it concerns fatals. It also concerns a number of issues concerning the breach of local standards, as well as the ambit of the package travel contract. Being cross-border practitioners, when you're at your CMC, you're likely to have some ammunition to say that it's in a higher complexity band given the cross-border nature of the claim. So I would say that it would fall, Astrid's case would fall within complexity band 3 in that respect. So what happens, say, if you want to, if you don't think the judge will really appreciate it? Well, actually, CPR PD 26, paragraph 3, gives you a tool, if you're a claimant or a defendant, to really highlight to the judge at the CMC or the person filling the directions questionnaire that this is a slightly more complex case than maybe initially thought. What this provision provides is that if you wish to give further information, you can send a document with the DQs saying that there is added complexity in this case. But the court will only take on to this information into account if all the parties agree that it's correct, that it should be put before the court, and a document containing the information has been sent to all the parties. Now, if we go back to Astrid's case, one thing that I could say as a claimant practitioner, if I was acting for the claimant, I act for both claimants and defendants, is that this case is likely to need expert evidence because you need local standards evidence. And that's something you can put before the court, which is relatively uncontroversial, but it's something that you can use them as a sort of a nudge to say that actually it should fall into a higher complexity band. We've all been in a situation as travel practitioners when we've had a case management order which, despite the fact of both parties agreeing that local standards expert evidence is required, the judge simply hasn't given permission for it, and that necessitates another hearing. So this sort of tool within CPR 26 may be quite useful in helping to push the judge into that conclusion. Now, challenging allocation and assignment can be done, but as Tom rightly noted, it is difficult. Allocation can only be challenged if exceptional, and the complexity band can be challenged if there is a change in circumstance. Now, we're in early days, and there's been a bit of light, but quite a lot of heat. If I were, say, if in a situation where you're a claimant, and you're running a package travel claim, and the claim defendant alleges in the updated counter schedule that there's been fundamental dishonesty, then in my view, there is some scope, it's not certain, to suggest that it moves into a slightly higher band, a complexity band 4. Because if a defendant's alleging fundamental dishonesty, then that seems to me to be a very serious issue of fact. Because what it means is that the claimant's at risk of contempt proceedings, it means they're at risk of enforceable cost orders. And in that respect, perfectly see a district judge saying, actually, well, yes, given the natural wording, it is a serious issue of fact and deserves further complexity, further bans. It also necessitates further work for claimant solicitors in investigating and dealing with these issues of fundamental dishonesty. The flip side of this is that if you're acting for a defendant, you need to be very careful and very sure before pleading fundamental dishonesty in counter schedules. Obviously, you need to be careful otherwise, but you need to know that it runs a risk of a claimant saying, well, actually, this entitles us to more costs. So here is the table for fixed costs for intermediate track complex band 3. I'm not going to go through this in great detail, but I'm going to go through a number of scenarios. The main focus of this is that the costs are much lower than what you would normally get if you're acting for the multi-track. And so, as I'll explain later, there are certain issues that claimants and defendant practitioners need to take into account when advising a client. So let's take, for example, Astrid's estate and dependents go to trial, and she succeeds. She's awarded £50,000. It's a 2-day trial, and let's assume that there've been no Part 36 offers, or nothing. There'll be no Part 36 consequences. How do you calculate the fixed costs? To my mind, the first thing you look at if you're going to trial is S8, which is the end of stage 6 to the date of trial. And that sets out £19,641 plus 20% of damages, minus £1,239 if the party did not prepare the trial bundle. So that's S8. You also have, assuming it's a 2-day trial, you have S9, the legal advocate, the advocacy fees, and 2 advocacy fees in that respect. So doing the basic maths of it, you've got £19,641 for your essentially pre-trial work, £10,000 for the 20% in damages, £1,239 for the solicitor, and I presume it's a solicitor because it says other than trial advocate, attending trial, and that's over 2 days. You've got £4,129 for the first advocacy day, and the second £2,065 to the second one. So in this case, rough estimate you would get is £38,313 for a 2-day trial where the claimant's estate or the Astrid's estate has been awarded £50,000. Of course, you also have to consider a London waiting. One thing I would note here is that the wording has slightly changed from the usual London waiting because now it instructs a legal representative with conduct of the litigation who practices in any of the areas. So CPR 2.3 provides that a legal representative is a solicitor or barrister or any other legal representative, but it's not sufficient now just to instruct a barrister from DECA because DECA practice in London and then say you can get the London uplift because we don't have conduct of the litigation. Interim applications, these are priced very, very low. The costs for an interim application in the intermediate track, say Astrid's estate wants to say um, do an application for specific disclosure, is just limited to £333, which is staggeringly low. Applications for summary judgment, interim payment, or an interim injunction are slightly more generous in terms of £750. The flip side of that is that disbursements actually have a pretty broad brush basis. It's based on reasonably incurred disbursements, other than those which are covered in the costs allowed in Section 7. Upshot of that is that issues such as your local standards reports, other sorts of expert evidence, they're at large, they're not fixed. So that's at least one sweetener to the lower interim applications. I hope that makes sense. Part 36. Now, this is, you'll be delighted to know, this is really, really complicated and not particularly well worded, in my opinion. But these are the implications as I see it, having gone through the wording at 1 o'clock in the morning last night. So, let's assume that Astrid's estate in this claim, she's made a Part 36 offer of £35,000 one day after the CMC, and the defendant accepts the offer. How do you calculate the costs? Well, you then go back to the complexity band, and for this, we're assuming that in the CMC they said, yes, it's intermediate track, yes, complexity band 3. You look at the fact that it's after after S3, so it would be S4, in my opinion. That must be correct. I'll get to it. Yes, S4, £11,256, plus the 14% of the damages, and that equals to £16,256. So the way you look at Part 36 is if you go, you need to go back to the staging within the complexity bands and work that out. But what happens, say, if the defendant doesn't accept the claimant Part 36 of 35,000, but the claimant beats their offer at trial? What happens is that you get an uplift of 35% on the difference between the stage when it expired and the stage is applicable at the date of judgment. So again, what you have to go for, I'm not going to do maths at this point, is you look at the trial, what would have been the cost of the trial minus the costs of that you would have of when it expired, the 11,300 at S4, and then you get 35% of it as a result. It's not particularly clear from the wording whether the claimant is entitled to receive the additional benefits of Part 36, the interest of damages, interest and costs, the additional 10% that we all know and love. But I think there is a good arguable point to it because it says in the wording of CPR 36.24 that it's subject to CPR 36.17. So if you're a claimant in that position, you can have a go at trying to get to it. So what does this mean overall? The problem for claim practitioners is that fixed recoverable costs lead to a greater risk of solicitor-client disputes. And that's because the only costs that can be recovered are those from the losing party and they're a set price of litigation. They take no account of experience of the fee earner or the time expended. And therefore, there's a real risk that a claimant, if they're not properly advised at the outset, a client might be concerned that they would have to make the liability of any shortfall between solicitor costs and fixed recoverable costs. You're all aware, I hope, of the case of Belsner and Cam Legal Services, which highlighted the duty under the solicitor's professional guide under the SRA Code of Conduct to ensure that clients receive the best possible information about pricing and the likely cost of the matter, such that they can give informed consent. And that means it's really important that you explain to the client about the effective fixed costs, about the risk of the shortfall of recovery, so they can provide informed consent to the retainer. And in fact, it may actually be worth sending them the relevant fixed cost table directing them to the likely complexity band and any other relevant factors, and ensuring the client has updates. Because if you don't, there are two issues that can happen. One, you may be in the situation that was experienced by JXC and NIS, where it was found that solicitors hadn't given informed consent. And second, that there is a risk of professional negligence of clients against solicitors for failing to advise regarding fixed recoverable costs. So it's something that it's really important to bear in mind when you're introducing a client to a case and setting out the basis of costs. For defendant practitioners, the fixed recoverable costs privilege later under Part 36 privilege later settlements in relation to the increase in costs. So you do have a risk of potentially claimants delaying tactically in reaching settlement. And for that, it's just really important to protect yourself, as always, by putting in Part 36 offers. For claimants to watch out and for defendants to think about, tactical admissions may be made in relation to breach or causation in order to narrow the issues and ensure that the complexity banding is as low as possible. Again, it's a fact that you will need to consider. Right, that wraps up what I have to say about the intermediate track and fixed recoverable costs. I hope that's been useful. We've got one question which has been
Well,
answered.
we've had two
Oh, we've
now.
had two.
One question which was answered, which for anyone who can't see it, was about what I referred to, because I think it was me who was talking about this. Foreign road traffic accidents. Did I mean accidents abroad or accidents in the UK involving a foreign party? I meant both, because under the RTA protocol, a road traffic accident is defined as being an accident in England. Yes, as being an accident in England and Wales. So essentially, if you have a road traffic accident in the Netherlands, it's not a road traffic accident, apparently, for the purpose of the protocol at least. So that's non-protocol. But it also excludes from its scope, this is the protocol, it excludes from its scope any accident where the defendant's vehicle is registered outside the UK, because then presumably the defendant's going to have foreign insurer, etc. It becomes more complex. So both accidents happening abroad and accidents happening within the UK, in fact, because it's only England and Wales anyway. So if it happens in Scotland, it's also a foreign accident. But in England and Wales, they're both non-protocol RTAs, and they would both go, therefore, into band 3 on the fast track as non-protocol RTAs.
So in relation to Connor's question, hi Connor, would a standard slip and trip that is suitable for the fast track and brought under the package travel regs fall under band 3? Again, this is all fact dependent. If we go back to the fast track complexity bands, which are somewhere around here.
There, that one.
Yes, I mean, it really depends on the defense that's being run. I would again, it's difficult to think about it, but I'd say there's definitely scope to argue band two on if you're dealing with a very simple breach of local standards. There's local standards evidence will be required, but in reality, it is just a slip and trip. That's if I was the defendant, I would be arguing probably around band two, and that's where also the tactical admissions can come into play. If you say if you accept, for example, if you accept, for example, that package travel regs apply and that you need local expert evidence, then that can help at least narrow the issues to some scope. But on my claimant head on, you can imagine a claimant practitioner such as me just saying that you're dealing with foreign law, you're dealing with foreign applicable standards, really, and the complexity of this matter means that it's probably safer to be within band three. I can see both sides in that respect. The difficulty with this is that given the novelty of these issues, we haven't actually really seen many judgments, not even from district judges at the moment. So ultimately, it's up to us to create the law and really work out the issues of this. Do you agree, Tom? Does that sound sensible?
Yeah, what I would say for the fast track, and it's different for the intermediate track because, as Anirudh said in his presentation, on the intermediate track, it's more dependent on number of issues, etc. In the fast track, it's more dependent on which bucket it goes into. Looking at this slide that Anirudh's got open at the moment, I would say the bucket that it naturally fits into is band three because it's although it's not a public liability claim, and I think I mentioned this while I was giving my part of the talk, it's not technically a public liability case. It is very, very close uh, in almost every way to a public liability case. Um, uh, Such that its natural starting point, I say, would be for like an ELPLPI case, would be in band three, notwithstanding that it's a contractual case. Now, but as Anirudh says, if you're a defendant and you want to limit these costs, you're going to be pushing for it to be in as simple a band as possible. So you're going to be trying to argue it up down into band two. And if you're a claimant, you're going to be saying, well, this is actually more complicated than your typical PL case because, as Anirudh says, you might have local standards evidence that you're having to deal with. And, what does the Spanish technical building code say about the thickness of window panes in a hotel or whatever it might be? That's more complicated than a English-based PL case normally. And so as a claimant, you'd probably be arguing for it to go into band four. This is on the fast track. So as Anirudh says, yeah, it's going to be the topic of hot debate. But I would say its natural bucket is band three, subject to argument and bit of judicial discretion. That's for fast track. For intermediate track, as Anirudh said in his talk, it really depends on the number of issues, and it becomes a little bit woollier in terms of complexity there. And you could easily say that an 80,000 claim for that arose out of a slip or a trip at a hotel could become really quite complex in situations where you've got disputed local standard evidence. You're having to call oral evidence from both local standard experts at trial. You might need translators. You might, we're all used to these kinds of cases that can spiral a little bit. And in the intermediate track bands, there's a little bit more scope for pushing complexity up or down. And as I said at the beginning, it really depends on the particular circumstances of your case.
Yes.
So ask counsel.
Yeah, it does cancel. A second point. What band would they estimate fall a Montreal Convention claim where the claimant living abroad, if liability is disputed? My understanding is that if you're living abroad, unfortunately, the rules just don't take account of you living abroad. So the mere fact that you're living abroad, and that makes it more complicated to deal with the claim, that concerns the claimant, the client, not the claim in and of itself. So that in and of itself wouldn't push you up and down. What really matters is the claim, as it were, and the complexity of the claim. Tom, what do you think?
Yes, I agree in all cases except for vulnerability. So
Yeah.
bizarrely, the only I say bizarrely, the only area in which it's possible to take into account the particular circumstances of the claimant in deciding whether or not a case is more or less complicated is actually when it comes to vulnerability. So, as I said, where your party is particularly vulnerable, and that vulnerability means you spend more money on the case as a lawyer, then you might be coming out of fixed recoverable costs. For I agree entirely with Anirudh that otherwise you're not going to get a different complexity of case and you're not going to get out of fixed recoverable costs simply because the fact of your client living abroad makes it more expensive,
Yes.
unfortunately.
It's interesting about vulnerability because vulnerability isn't actually defined in the CPR. It just gives examples, but in some ways, all of us are vulnerable. So all of us have these these issues in that respect, which I've always found that fascinating. How some people are considered vulnerable and some people are not. When in fact, all of us in some way and in some time will be vulnerable. Last question. When the value is £45,000, court orders still come through saying proposed allocation to multi-track. In cases where FRC are applicable, Would you also file a front page budget with the DQ to comply with the order? Um, well, if it says proposed allocation of the multi-track, I think what again, it really depends on the case, and in terms of when it's been done. Because if the court order has come through saying proposed allocation to the multi-track, then presumably that's either because it falls within the exceptions or there's been some other issue outstanding about that. Would you also
Yeah.
find, I guess you would comply with the order in and of itself, and then you get to court and the judge says there should have been an intermediate track case, and there we are. Um, yeah, it's
I
a
think that's right. It feels like it is either if it's a 45K case, it's the order is either an error, you get an error, and that happens all the time. Um, you get a proposed allocation which is just wrong, or it's because fixed recoverable costs are not going to apply because you're in one of the exceptions, i.e., a clean neg case where you haven't got the everything admitted. So in those circumstances, if it's either wrong, in which case I agree with Anirudh, you do your best to comply, but also make clear that this is not a necessary exercise, or it's not wrong, in which case, of course, you submit it because you're going into the multi-track anyway.
Yeah, I've had cases where you go to court and the judge says this is all wrong, isn't it? And we say
Yeah.
yeah, and you say okay, let's do this all from scratch. But if in doubt, just comply with the court order so that you've covered your back. Great. Well, unless anyone has any further questions,
And
that
we had a couple. I mean, people can obviously we're over time, so people can disappear whenever they're convenient. But we did have another couple of questions by email, and while I pull those up, I just wanted to say in terms of Part 36, my understanding um, of 3624, the new 3624, is that it is absolutely subject to 3617. We start at 3617. We make the usual orders about 10% uplift on damages, etc. And then when we go to 3624.4, it says where the court makes an order pursuant to 3617.4, instead of costs awarded on the indemnity basis, the claimant is entitled to, and then that 35% uplift in the difference between the two phases. So I think we still start, my reading is the same as yours, Anirudh, that we start at 3617, we make those usual orders, but instead of having assessed indemnity costs, we now have this new 35% uplift, whatever you might want to call it. Now, let me just check these questions for email. I think one of them was, in fact, on the Montreal Convention, so we've already covered that, so that's helpful. Will fixed costs apply to an accident abroad falling under the package travel regulations in the same way as illness cases? Well, yes and no. It will apply, but probably not in exactly the same way as an illness case, because in the fast track, an illness case would fall, which most illness cases are, because typically you don't get illness cases that are worth more than 25K, but you can do. But typically, an illness case would go into band two on the fast track because it's a PTR protocol case, whereas a other PTR accident, a slipper tripper, would go, as I say, probably naturally into band three, although it could be argued up or down. Second question by email: what happens if a claimant is entitled to fixed recoverable costs of 1,000, but the actual costs incurred with the solicitor are 500? So a sort of bonus to the solicitor. And I think the short answer to that is it doesn't matter at all. The whole point of the fixed recoverable costs regime is to do away with assessment of costs by reference to the indemnity principle. So it's recognised, I believe, by Lord Justice Jackson and the wisdom of those putting together this regime, that in some cases, claimant solicitors are going to win in terms of making larger profits, and in some cases they're going to lose, i.e., run cases at a loss. There's no indemnity principle, as far as I can tell, set out in Part 45, and so the number is fixed no matter what you spent on it. So there is a possibility of a windfall. Anirudh, I don't know if you agree on that reading of Part 45.
Yes, yes. The cases Nizami and Butt.
Oh, there you go. You've got a
2006.
K. Fantastic.
The court held that indemnity principle doesn't apply to fixed recoverable costs.
Fantastic. Well, there you go. That's that one. And we've done Montreal Convention. Next question here. In which band do they estimate would fall a PTR claim for a protected party, vulnerable adult domiciled in England and victim of an accident abroad? The claimant had pre-existing learning difficulties, disability not related to the accident. What if her claim is not a package claim, is pursued in England, assuming jurisdiction is not an issue, but a foreign law applies? Okay, well, first of all, it depends whether we're on fast track or intermediate track. Second of all, we've got the point that Anirudh made about protected parties, fixed recoverable costs don't apply. Vulnerability of the witness, if it creates 20% more work or 20% more cost than otherwise would be recoverable, then that of course would lead to standard assessment. And whether or not it's a PTR claim or a non-PTR claim, I think it's still on the fast track really becomes a question of band 3 or band 4. And on the intermediate track, it's really a question of how many issues there are, how complicated the issues are, and it becomes a little bit more woolly. Would you agree, Anna?
Yes, I agree.
Yeah. And final question, 12.5% London weighting for a foreign claimant who resides abroad but instructs a specialist London firm. Well, I think I dealt with this already in the talk. The London weighting is conjunctive, so it applies where the receiving party is resident in London and the representatives are practicing from London or the very surrounding areas like Uxbridge and Croydon and Bromley, etc. So the fact of the claimant residing abroad wouldn't give you a 12.5% London weighting, even if the place they lived abroad was as expensive or more expensive than London.
Yes. There's a question that's just come in by Mike. In intermediate track case where the claimant has to apply for permission to serve out, what costs are recoverable in respect of that often complex application? Um, my preliminary view, this is just the first thing I'm thinking, and I'd be interested to hear your view, Tom, is that at the stage of serving out, it would be under no track whatsoever. Track allocation wouldn't have happened. So, therefore, the costs are at large, unless I've got that completely wrong.
Yeah, well, I don't know. The problem is that and now I've got the problem is swapping hats. In the old regime, allocation, as it were, backdated recoverable costs. Because if it was subsequently allocated to the fast track, the fixed costs would apply as a sort of backdated way. But
Yes.
I think although I think at the end of that application you'd have the assessment of costs then and there, wouldn't you? And I think it would be
Yeah, yeah, that's what I was thinking, and therefore you would
yeah
say we don't know what track this. It may go into. It's likely to go into the immediate track, but currently it's not allocated. So there we are. I think it's an argument worth running, and we're still trying to tease this out.
it's
Um,
certainly not acceptable to recover only 333
£33
pounds
for
for a
for a
contested
complex application.
jurisdiction application.
Yes, and also in those circumstances, I would say that. Well, I would say to the judge, well, I appreciate it's an interim application, but it's a very complex application, and it's not just your normal strikeout, result from admission or whatever. It may be worth just pushing, even if they find that it belongs to the intermediate track, that it has exceptional circumstances. Again, the answer is I'm not quite sure. I think I need to have another rummage through to think about whether the backdating effect would work. But
Well,
again,
what I definitely say is make sure you get an assessment then and there, and
yeah,
don't get batted off to a later date.
yeah,
Because if you do get them batted off to a later date, there's a real risk that if they come to be assessed at conclusion of trial, you're only going to get the 333.
yeah, yes, that's it. That's it. Right, I hope that's helpful. Is that everyone? Grand. Oh, okay. Well, you have our emails. The slides will be sent through, and if there are any further questions, oh, just one more.
I know it's just a thank you.
Oh,
Thanks.
it's a thank you. Okay, great. Excellent. If you have any further questions, the emails will be circulated around, and you'll be able to ask on that, or just contact Emma or Milena. Great. Thank you very much. Take care,
Thank you
everyone.
for those of you who stuck around as well. It's a lot later than we hoped. Sorry about that.
No problem. Take care.